Good morning, almost good afternoon. I'm very pleased to be here today, and like other speakers and guests, would like to really sincerely thank the invitation to the President of the Portuguese Competition Authority, to Nuno, and also, of course, big thanks to Ana Sofia and Miguel. And allow me to say, since I was at the beginning of the Portuguese Competition Authority, which I always considered a great privilege, it is a pleasure to be here with the whole ADC team and to see how the authority has flourished and done a fantastic job over the years. Allow me also, because some of you may think, okay, apart from being Portuguese, why is she moderating this panel? I am the head of competition and consumer policies of the United Nations Trade and Development, better known as UNCTAD, which happens to be the focal point for competition and consumer policies within the United Nations system. And I wanted just to share with you that today is the United Nations Day. And we celebrate 80 years of the United Nations, focusing on this vision of peace through cooperation and dialogue among nations, which is needed now more than ever, which is a sentence that is very much used by the United Nations officials, but I think it resonates with all of us. So I wanted just to mention this and to tell you that, of course, all your member states, for the many colleagues and friends that come from other European countries, other partner countries, and I would like, of course, to mention Brazil, the Portuguese African countries, Portuguese-speaking African countries, and Timor-Leste that are with us here today. It is fantastic to see that the authority chose so many timely topics that are under discussion, under transition, as we heard from the President of the Court. And with this, I will start our panel. So, a very ambitious and broad title, Chartering the Next Legal Frontiers in Antitrust Enforcement, to speak about the revision of Council Regulation 1/2003 that has been in force for a little bit over 20 years and has really caused a revolution in the enforcement of Articles 101 and 102 of the treaty. So, Regulation 1/2003 stands as the revolutionary framework that has shaped the European competition enforcement in recent years, and its ongoing revision provides an opportunity to assess its application and address possible improvements. As we see, there are a number of European competition instruments that are currently being assessed and probably will be revised, which is a very timely, important, and healthy, I think, exercise that should be followed all over the world. But the experience of competition enforcers and private stakeholders has been already called upon the debate so that antitrust enforcement avoids falling behind this ever-changing European and worldly economic landscape and move forward to finding more effective ways to investigate, detect, and deter anti-competitive practices in Europe. I have a stellar set of speakers, starting, of course, with Cani Fernandez, the chair of the National Commission for Markets and Competition of Spain, Fernando Castillo de la Torre, Principal Legal Advisor, Legal Service of the European Commission, and Richard Wish, Professor of Competition Law, King's College, London. I would like to set the stage with a couple of references that very much were chosen considering the framework of the ongoing assessment of Regulation 1/2003, just reminding all of us that this regulation establishes procedural rules for the implementation of the main European competition provisions, of course, Articles 101 and 102, and have introduced a decentralized enforcement system, which was a complete novelty. This new regime comprises the direct applicability of Articles 101 and 102, including, of course, 101(3), the empowerment of national competition authorities and national courts to apply these rules in their entirety, the closer cooperation between national competition authorities and the European Commission under the European Competition Network, the ECN that you are all very familiar with, and increased investigative and decision-making powers for the Commission. So, on this note, this system, which, as I said, has been in force more than 21 years, interestingly entered into force coinciding with the largest enlargement of the European Union, therefore, a considerable expansion of the single market. The ongoing revision process is driven, according to the European Commission, of course, by concerns related to the growing digitalization demands and a concern of more effectiveness. DG Comp underlined the strengthening of its investigative and decision-making powers and the cooperation with national competition authorities as issues that would be considered. Since the public consultation ended at the beginning of this month, and there are already some statistics and a first preliminary evaluation of the contributions, their origin, the trend, let's say, of these contributions, it is now timely to hear from this highly qualified and experienced group of speakers, whom I'm very privileged to moderate. So I would like to propose 2 rounds of questions and start with Kani, regarding the general assessment of Regulation 1/2003 implementation. From the point of view of CNMC, what is your assessment? And could you please address in particular the cooperation between national competition authorities and the Commission and the functioning of the ECN? Over to you.
Thank you very much, Teresa. Thank you, Nuno, Ana Sofia, Miguel, again. I am so glad that I can contribute also in something that's more legal than yesterday's panel with industrial policy, which is a bit more abstract, although it's really important. Here I feel more on my skin because we are going to talk about law and legal review, so here we are. So as a national competition authority, I would qualify Regulation 1/2003 as a clear success. I think there are 2 positive impacts that immediately arose from the adoption of Regulation 1/2003. One is that it freed resources for the Commission to be able to tackle issues of really impact at the European level. The previous system in notifications was extremely time-consuming and not necessarily efficient. So in that respect, the Commission was able to focus in more damaging practices that had better in their enforcement, better impact in the internal market. And at the same time, it multiplied the number of enforcers because from one day to the following, the Commission had many arms and in every single member state. So yesterday, Lindsay was reminding that nowadays around 85% of the enforcement of Articles 101 and 102 are done by national competition authorities. In the report that the Commission published preceding the review of Regulation 1/2003, the numbers are quite stunning. I mean, it's 1,470 decisions on 101, 102 were adopted by national competition authorities. In the same period, the Commission adopted 169. So just imagine the impact that this has had in adopting or increasing the enforcement of 101 and 102 on competition law in the internal market. And I think this has provided for and then I will talk about cooperation, because of course the potential weak point was whether we would be able to do it in a consistent and coherent way. But if we were able to, it was clear that the competition was going to be strengthened in the internal market. So helping achieving the internal market, which I think it is our main strength in Europe, and that is why in nowadays times where resilience and having a potential market where we can all thrive, innovation is rising, is so important. So it's not a trivial question, but of course it was really important that we were able to do so in a consistent and coherent way. And of course, when you have 27, at the time 28, member states that are having different legal traditions, that are having different institutional structures, of course there was a legitimate doubt on whether we would be able to. So the design in Regulation 1/2003, and concretely Article 11, was trying to establish a system of cooperation among the different national competition authorities and the Commission that was based in an early notification of cases whenever we were investigating a case. Before a formal opening of a case, we were consulting, we were cooperating with the European Commission to see whether the Commission had or not opened a case on that particular practice. And then before adopting a final decision, when we had already a draft decision, there was a second moment of consultation with the Commission in order to ensure in the content or on the content of the decision that it was consistent with the previous practice of the Commission and also of other national competition authorities, because by applying consistently this Article 11, we were at the same time being able to have this hub on the Commission to the spoke of all the other national competition authorities. Now, there is also a rule that would apply in order to avoid any inconsistency, that it is that no national competition authority is allowed to take any decision that will counter what the Commission already said. So we created, by doing so, a system of consistent and coherent application from a formal point of view. What has happened is that through regular contacts among all the national competition authorities and the Commission, that happen at least twice a year in person, we have created also a community in which we not only cooperate, but we also exchange our know-how. And this is extremely important because I think that has increased the level and also the rigor in the application of our competition enforcement regarding Articles 101 and 102. Whenever we meet, we discuss, we exchange views, we also learn from each other. If someone has developed a new theory that has been difficult to prove, we study it together, and this improves the level of enforcement. So it's not only the formal case allocation that is working, which is, as you all know, based on the best placed authority, be it because the complaint has been launched in one member state or because the effects are more felt in another member state, but it is also a question of how we are developing this common knowledge in the application of our competition enforcement. These best practices that are not written anywhere, but that are common sense at the end of the day of the enforcement, I think have helped reaching the understanding of where we are strong and where we are not strong. And I would like to say that the ECM Plus has been also an instrument that was the result of long discussions, reflections, and contrasting what was working and what was not working. So the ECM Plus, I think, came to help us very much in order to be able to reinforce and strengthen our competition capabilities, because we were seeing that some member states were not having the same possibility that others were seeing. So that was possible thanks to the ECN and the level of checking and comparing that we were able to do. A last point with this, I think it has become such a virtuous community that when talking about the DMA, I think that is the right model to avoid parallel enforcement and to be more efficient. I think we have provided a very, very good example. Let me just illustrate some of the cases in which we've been able to cooperate very, very much. not only in Article 22, that, as you know, allows us to conduct downgrades in coordination. We've done that with Portugal with the Portuguese Competition Authority, because our markets tend to be global. We've done that several times, and also the exchange of information inside the ECN. But there are other examples that illustrate this. For example, the Apple-Amazon brand gating case that we find in Spain in 2023, which 190 million euro, which at the time was one of the highest fines. That was possible due to the cooperation with the Italian Competition Authority. We got some information inside the ECN about these practices. We realized that they were impacting in Spain, and we had the help of the Italian Competition Authority. Or in the Lydian case, we were helped by the Dutch Competition Authority. One just mentioned, because there is room always for improvement, and I will refer to what Professor Jenny was saying yesterday. In the booking case, you mentioned many cases that have been imposed or adopted in different jurisdictions. You didn't mention Spain. Spain was also in the list. We imposed a fine on booking of 413 million last year. And it is true that there are many cases. And maybe it would have been better for the Commission to tackle the case. Same thing with Lydian and others. But I have to tell you that at the end of the day, it's true that we need to cooperate, but it is also true that for certain member states, and this is the beauty of, I think, Regulation 1/2003 and the cooperation, maybe the effects that are felt in a specific market may be demanding immediate action. We are on the front, and we see how it was happening. And while the discussion on narrow and wide parity clauses is a very important one from an academic point of view, what we felt is that our tourism sector in Spain was suffering a lot. So that's the reason why, even coordinating with the Commission, we felt that we needed to react, and we did so. So from time to time, I think there is room for improvement, but we cannot forget that those that are having our SMEs come in to ask for help are there. So that's also something that we can discuss if we go on the points that have to be or not harmonized. And I will refer to the unilateral conducts later on in the second round. But I wanted to say that there are many positive impacts and some things to be corrected, maybe with further cooperation.
Thank you very much. Of course, I think the success of the ECN, and in this case of Regulation 1/2003 implementation, is shared by everybody. But as Kani mentioned in the beginning, there were some legitimate doubts, I think, especially with the enlargement coinciding. Thank you for mentioning the ECN Plus, because I think this also shows that, well, the Commission and the Member States did not necessarily wait to have a very long period of implementation to assess. So this close cooperation and lessons learned also has also allowed the EU member states to align a little bit further and to improve its effectiveness. And of course, the final comment that you made, well, of course, the success of the European single market is a goal shared by all member states, but national markets sometimes remain a little bit specific or with their own features for obvious reasons. But I would like now to pass to Fernando, of course, from the legal service from the Commission. I would like, Fernando, to hear you on this assessment. Maybe you could talk to us also about the cooperation between the national competition authorities and the Commission from the point of view of the Commission, and also refer to some procedural matters that you find key in your daily job.
Yeah, thank you. I think overall everyone agrees that it has been a success story in the sense that everyone thinks it was a very positive development as a result of Regulation number 1. Sometimes nowadays I see that we take for granted a number of things and we don't realize so much about how important the change in 2004 was. And I will maybe make a couple of points about that later on. Regulation number 1 has provisions on the Commission proceedings, and then of course has provisions about the national level. I will try to cover both very briefly. About the Commission proceedings, in terms of powers of inquiry, one of the main novelties at the time was the possibility to take statements that remain voluntary, and this is one of the areas where some changes may be needed, but there was no big revolution for the Commission on that front. The big change there was more in the decision-making processes. Article 9 allows now the Commission to make commitments binding, and we can see how nowadays actually more than half of our decisions are Article 9 as opposed to Article 7. So this is a tool which has proven to be very successful. At the time, it was feared that the Commission, in the same way as later on the settlement, which is a bit of a different animal, would misuse these proceedings, but I think nowadays everyone agrees that this is a very efficient tool to enforce competition law. But of course, it's all based on the consent and the cooperation of the undertakings. At national level, precisely between the two, so to say, the big change for the Commission was that it was relieved of the monopoly of application of 101(3). And people underestimate nowadays, I think, this issue. At the time, it was decided that this monopoly power the Commission had was going to be lost, and now national authorities were able to apply in its entirety 101. It's not a light issue, because actually one has a look at 103 of the treaties. It is the Council that determines in which way paragraph 3 of 101 will be applied. So some people think nowadays that 101 has direct effect just like that in its entirety. Well, the issue is not that simple. So this change, now we accept without further ado, 101 is applied at national level, was a very important change that was brought about at the time by this regulation. Of course, other important changes were that nowadays all member states have a duty to have competition authorities. They all enforce the same laws. We have been discussing sometimes about the changes. Some people think, much of what we see nowadays about national competition authorities enforcing 101, 102 would have happened anyway by be the direct effect or the fact that some of these competition authorities already in the past, in the 90s, have been applied. Sure, some of it maybe yes, but not to the same extent. I think the fact that it's the 27 member states who have to do it, and need to have the tools, and then you have ECM Plus also adding a number of requirements that EU national law has to comply, has been very important. Also because you can only create the tools for cooperation through EU law. I mean, direct effect will not solve the problems of, or will not provide the tools for member states and the national competition authorities to cooperate between them. That's something that can only be provided for in the law. There was the perceived risk in decentralization of lack of uniformity. When I see the different studies we see nowadays, there was an evaluation study last year in 2024. Now we have a call for evidence for the impact assessment of some of the changes. We will discuss about that a bit later on. There was the perceived risk of lack of uniformity as a result of everyone can apply EU law. What is it going to happen? In any legal system, you have plenty of people applying the law. It does happen that you may have somewhat inconsistent decisions, but I think all systems have a Supreme Court that will, of course, ensure the uniformity of the law. Here we have the ECJ, and we have systems of cooperation where national competition authorities will inform the Commission in advance of some key steps, some key decisions. We have a look at that. I think it works very well in the sense that when there is some feedback to be given, we give it. Of course, we don't get into the facts of the case because the Commission and the Commission services care more about the uniformity of the law, that there are no inconsistencies, about, of course, incorporating so that they don't overlook some aspects of the law eventually. But I think that overall, my impression, we are also involved as legal service in many of these consultations, goes rather well. This uniformity, however, doesn't mean, and that's, I think, a great thing, that there is no room for creativity. The Commission can only deal with a few cases a year. Mm-hmm. And In some cases, national competition authorities have been, in a way, bolder than the Commission, have gone ahead with cases that the Commission couldn't take or didn't want to take, in some cases. We see, for example, all the wave of cases about sports nowadays. The Commission has been, in general, reluctant to do sports cases over the last 20 years. Most of the great majority of preliminary references at the moment come from national cases. But we have seen many judgments over the last 20 years where the ECJ has developed the law, which are the result of national cases, sometimes cases brought by the National Competition Authority. So I think overall it's been very good. I think the uniformity of the law has not been undermined, but this has also the fact that it's not only the Commission but other competition authorities, which of course have the resources, necessary resources, and some of them have been bold enough to eventually test a bit the limits of the law, has also been very, very helpful. It was just, I think, mentioned just a while ago, the Android Auto case, again, an Italian case that has redefined sometimes the limits of 102. Again, a national case brought by the National Competition Authority. Again, it doesn't mean that, of course, it is all perfect and there is nothing to improve. We will discuss a bit later. Sometimes, for example, one aspect which is sometimes criticized, and I understand it, is that the system was very much focused on prosecution. I mean, we have the theoretical possibility of having inapplicability decisions. We never adopted. We have started to provide more what is called informal guidance. There was a new notice on informal guidance a couple of years ago. We have actually provided 2 of them, I think in July. They are published in the OJ. And this is something that people criticize, that eventually Commission, eventually competition authorities should be able to provide a bit more positive guidance about what is allowed. Having said so, the Commission publishes regularly, of course, guidelines on horizontal restrictions, on vertical restrictions. Now we're working on guidelines 102. So it's not that there is no guidance out there about many aspects of EU law, about the substantive law. And even, and this is my final comment, even if the Commission has been given the tools to be more efficient with, for example, Article 9 proceedings, when a company fights in the sense that it doesn't provide commitments, when it really wants to make things difficult, the reality is the procedures have become a bit longer. There are several reasons for that. One is the mass of information that we can collect nowadays because of digitization. We will maybe revert to that may have to rethink how process goes. Of course, if you have more information, and then you also have little by little case law that is stricter on procedural guarantees, when you have to have more information, procedural guarantees, access to file, confidentiality. Then also you have a substantive legal test that eventually may create more complexity in some cases, because maybe you don't have clear-cut and bright-line rules. You may have to have a look at all the circumstances of the case, which in some cases may involve a more complex investigation. So the reality is that despite the fact that we have been given some tools to be more efficient, when a company wants to fight a case and wants to make our life difficult, the procedures are still nowadays very long. And we have a few cases over the recent years where investigations in the Commission have taken something between 5 to 6 to 7 years, which objectively it is a lot. And with that, I stop. We will talk about.
Thank you very much. Well, thank you, first of all, for mentioning, of course, the workload previous to Regulation 1/2003 regarding the application of Article 101(3), because the exemptions took a long time, and of course they corresponded to a huge amount of work of the Commission, again, which needed, of course, to focus on more important EU-wide cases. I think that's very interesting. Also, the new powers, now they seem obvious, like commitments, but I remember that the new investigative powers and sort of decision-making powers of the Commission, which also then inspired national competition laws to become much more flexible. And I remember that from a strictly legal point of view, at national level, we were discussing every detail, trying to understand how far did you have to go to state that there was an infringement or not, and all these consequences. And all of this, I think, has become extremely successful and allowed for much more effectiveness of European competition law enforcement. I think the uniformity is really an issue, and I will ask Richard to reflect on a number of things, of course, as an academic, of course, on basis on your very vast experience, from your point of view, what are not just the stronger features, because we have already heard several of them, but the areas for improvement, considering the architecture, but also the implementation of Regulation 1, and maybe talk a little bit about 101.3, what has become of Article 101.3 nowadays, and how courts have been, well, enforcing 101 and 102, or reviewing national and the Commission decisions enforcing these articles.
Well, thank you, Teresa. Let me start with a heartfelt thank you to the authority, Nuno, Ana Sofia, Miguel, for the invitation to be here, because here we are talking about the future of Regulation 1 and how in the next 20 years EU competition law is going to be enforced. And I'm from the UK, and we have Brexited. And we've reached a point now where Brexit is no longer recent. It's actually 5 years ago that we left the EU. So I kind of find myself thinking, why am I here? And then I reflected that obviously it's the Anglo-Portuguese Treaty of 1373, which, as you all know, is the oldest international treaty still in force today. And I reminded myself this morning of what it says. It established a perpetual friendship, union, and alliance between the UK and Portugal. So that is, as it were, the legal basis for me being here. And as far as I know, there's no proposal in the UK for a referendum on the Anglo-Portuguese Treaty, and I don't think anyone in Portugal is proposing Pexit. So I hope to be invited again in the future. Now then, this round of questions, we're looking back at Regulation 1, and slightly picking up on something that Fernando was saying there, is that, of course, I remember the late 1990s when this first was proposed, and decentralizing enforcement to 28, eventually now 27 member states. And it really was profoundly radical, what was being suggested. I think younger people in the audience probably don't understand just how radical that was. I mean, when John McEnroe heard about it, he immediately said, you cannot be serious. How could you possibly do this? But it has worked extraordinarily well. I liked yesterday morning when Lindsay McCallum said, we took a bet. If I heard her properly, she said, we took a bet on this, and it worked out okay in the end. And so, like Judge van der Woude, I thought I don't want to upset economists, so I've brought some numbers with me. Looking at the statistics, since Regulation 1 came into force, there have been 3,420 investigations started, of which 524 were by the Commission and 2,896 by the NCAs. Now, of course, numbers are crude, but that does tell a story. The overwhelming majority of enforcement is done at local level, if you like. And the model one can envision here is that the Commission is going to set policy and do the really high-profile cases, the mega cartels, the Google shopping, Android, etc. And then the NCAs would do the prosaic stuff of the local bid rigging cartel and the local RPM and whatever. And so the image there is a bit like a beehive, where you have the queen bee who stays in the hive, directing operations, deciding the future of the colony, and then the workers just go out day after day after day, collecting the pollen and coming back for the queen's pleasure. So that's the kind of model that one can envisage. But what I have found fascinating over the 20 years is the way that it's kind of changed. Because if you think of the innovative cases, setting new policy, experimental theories of harm, etc., it's not all been done by the Commission. There are lots of exceedingly interesting cases that have been done at NCA level. And this does contribute to know-how, because it means it's not just the Commission that is coming up with new ideas. NCAs can do it as well. And then within the ECN, it feeds around the circuit. And indeed, there have been cases where national authorities have experimented with an idea that has subsequently led to the Commission taking a case in the same area. All very interesting. Let me give you a few examples of this. Here we are in Portugal. And the Portuguese authority has done wonderful work over many years recently. And I think of something like the hub and spoke cartel. We all know about hub and spoke cases in theory, but there aren't that many of them in practice. Well, you've got a very good example of that sort of thing being looked at here. No poach agreement, obviously, in Portugal. AGCM in Italy. What did we hear of yesterday? What was one of the prize winners for the SA prize? Google Android Auto. This is an absolutely enormously important case, and we're going to be talking about it for a long, long time to come, and that came from Italy. Also, Italy did the excessive pricing case in the pharmaceutical sector, Aspen, and the Commission hadn't done an excessive pricing case for donkey's years, if ever, almost. And what happened after the Italian intervention there? The Commission opened a case against Aspen and actually in the end got commitments from them to reduce their prices. Germany, well, there is the little matter of the Facebook Meta case, immensely important, that went from the BKA up through the German courts to the Court of Justice in Luxembourg, and that's an incredibly important judgment that set all sorts of standards for the future. I look at the French authority, very, very active, in particular in relation to digital platforms, a lot of very important cases that they took. The Dutch authority went on ahead with the issue of app stores and Apple. The first decision finding Apple to have abused in relation to the App Store was in the Netherlands, and that's been upheld on appeal. And then another example of the same thing, I would say, let's look at the issue of disparagement. If you were to count up all the cases now within the EU on disparagement of a competitor's products, certainly more than 10 at NCA level. And now, in the last year, the Commission has adopted its first disparagement decision. But the inspiration behind that, it seems to me, very much comes from the local level. So I think it's just a very interesting account of how things have developed over 20 years. The next point I was going to make is very brief, and you mentioned the courts. Of course, one of the difficult things with the regulation was going to be how are cases going to be allocated? Are they going to be taken at local level? Are they going to be done by the Commission? And I have been interested to watch the appeals that have gone to the General Court on case allocation. And I'll put it fairly simply. It seems to me the court has been very understanding of how this system was meant to work, and they have resisted loyally legalistic arguments about misallocation of jurisdiction. And I give as a few examples the Silgan metal packaging case from Germany, where there was an issue over German fining law as it existed at the time. The case was transferred to Brussels. There was an appeal against the reallocation, and the court said, we don't have a problem with it. Amazon was being investigated in relation to some platform practices in Italy, and then the Commission opened their own investigation of the same kind of practices, but excluded Italy. Was that a violation of Regulation 1? Court says, in principle, no. Other cases where an authority had looked at something and then a complainant, as it were, has a second bite at the cherry by saying we didn't get what we wanted from Slovenia, that was the C-Mobile case. We didn't get what we wanted from the Dutch, that was the EasyJet case. And so now we go to now we go to the Commission, And the Commission says, no, this is all dealt with under Article 13 of the regulation, and the General Court in both of those cases upheld the Commission. So that seems to me rather interesting. The Court very much understanding the spirit and the purpose behind the regulation. The next thing I was going to mention was the business of declarations of inapplicability and informal guidance. And this does bring me on to the 1013 issue. So what was the central proposition of Regulation 1? No more notification to the Commission, no more individual exemptions, no monopoly over 1013 for the Commission. So the whole of Article 101 is directly applicable, and basically companies, you've got to sit down with your law firms and assess the matter for yourself, including the application of Article 1013. Well, that's what it was all about, and it has worked extremely well in practice. But I do remember a lot of people saying, but sometimes we might need some assistance from the Commission because some new practice comes along. There's a need for some kind of agreement that's never been looked at in the past. None of the Commission's guidance covers what it is that we want to do. Sometimes it might be helpful to go to the Commission and get it to declare its position in relation to an agreement or a practice. And it was recognised that this is a legitimate concern, and so the regulation ends up with Article 10, the so-called Declaration of Inapplicability, where the Commission could look at something and actually say, competition law doesn't apply to that. Well, here we are, 20, whatever it is, 1 year later, there has never been a Declaration of Inapplicability. That's simple, straightforward fact. What about guidance? And I think it's recital 38 of the regulation that said, in appropriate circumstances, where there's a public interest, the Commission will have the right to give informal guidance. And of course, there's a notice on that that's recently been revised somewhat, not radically, but been revised. And so maybe this was a way in which you could sometimes get the Commission to give you a steer. But of course, the quid pro quo of the Commission giving informal guidance was that that guidance would be a public good, it would go into the public domain, and so what I want to do will be known to the world. And totally understandably, most companies don't want their affairs to be reviewed in public, and so people didn't ask for guidance, and if you don't ask for guidance, of course, you don't get it. Recently, of course, the Commission has done it twice within the last few months, but historically there was very little guidance. Well, okay, I understand all of the above. One thing that slightly worries me about it, though, is that in the old days, when I was learning my competition law in the beginning, I learned an awful lot from reading individual exemptions, because there would be cases where the Commission says, you know, these rules for establishing this trade exhibition, they are actually restrictive of competition in various ways. On the other hand, they lead to benefits, to technical benefits or economic benefits or improvements in production, and consumers get a benefit. And one was able to learn a lot about how 1013 applied in practice from those decisions. But of course, obviously, you don't get those decisions any longer. You don't get a positive application, ever, of Article 1013. You get plenty of negative applications when you've got some LIBOR rate fixing or whatever, and then, you know, the last throw of the dice, you know, we didn't do it, you've got the facts wrong, and anyway it's efficient. Well, of course, that gets rejected. So what you get from competition authorities is rejections of 1013 arguments, but you never get positive affirmations of Article 103 being satisfied. And it seems to me that this has a slightly unfortunate effect, because it's almost as though Article 1013 has evaporated and no longer exists. And I think you get these endless cases on is it an object or an effect restriction. I mean, I'm bored silly with judgments on object-effect distinction. Yesterday, you get it in Teva and Kefalon, where, of course, actually Teva is saying it was wrong to say that this pay-for-delay agreement was a restriction by object because it was pro-competitive and it led to efficiencies. Well, and the court rejected that. In olden times, you might have been able to say, okay, Commission, you think there's a restriction of competition here. It doesn't really matter whether it's object or effect. Now let's go on to the interesting discussion under 1013. Are there benefits here, and will consumers get a share of that? And it actually seems to me that's a much better way of deciding some of these cases. There are more words in 1013 than 1011, and yet we don't use them. And it seems to me that this is all a little bit unfortunate. And there's a judgment of the Court of Justice, Tele2 Polska, that says that a national authority cannot make a decision that 101 is not infringed. It can decide as a matter of priority not to investigate something, but it cannot say that 101 is not infringed. Well, as I see it, therefore, that means that a national authority cannot positively apply 1013, because that would be a decision that 101 is not infringed. I've never seen anyone talk about that, but logically, Fernando may have a thought on it. But so I think there's an interesting issue around 1013, and maybe we've lost words that in some cases might be very useful.
Thank you very much. Very interesting remarks. Well, thank you for sharing also the stats, because I think they really tell something. And I think it's very encouraging to hear. I mean, of course, Kani had already mentioned a number of bilateral or trilateral collaboration between NCAs. But you are absolutely right, because when Regulation 1/2003 was enacted, I think there was this concern, even for some more than others, that the Commission would really, as you described, would really, well, always have the final say. I mean, it makes sense for a number of cases, but I think especially for the national, most experienced competition authorities of bigger jurisdictions, that was perceived as a concern. Probably not for some of the new member states that joined in 2004, but it's very interesting to see this dynamism and innovative approach from so many national competition authorities, and I think that's very encouraging regarding the success and the adaptation also of the ECN, which I should say, going back to my current job, it's very much a source of inspiration elsewhere in the world. I would say at personal level, not necessarily for the best reasons, because I think a number of colleagues from all over the world in developing countries think that it's very easy to replicate an ECN, while of course there's the single market, there is the community of values and principles. It's much more demanding than just cooperation, but I think it's a very good example of very effective cooperation. I move quickly to the second and final round to get to the wish list, so to speak, since we have heard that the Commission will organize an interactive workshop in December, 15th of December, I think, so probably preparing or moving forward towards some sort of legislative proposal. So Kani, for you, what would be the most important amendments with this view, of course, of improving effectiveness, having in mind, because I think all speakers, since the conference started, talked about the importance of having an improved, more effective European single market. So, and considering the very important role that competition policy has had in building a successful and effectively functioning single market, what would be your choice of topics?
Well, let me go more into the pragmatical approach that national competition authority experiences when dealing with cases where we see still some areas of convergence that I think could be included in the review, and that I think would help us a lot. One of the things that I would suggest to tackle in the new regulation would be a methodology of calculation of fines. Because we experience that the same practice may be 10 times fined in a jurisdiction compared to another jurisdiction with no difference in the impact or the gravity or the duration. So it's also, for example, in Spain, a question of on whether you have judgments from your courts that are not aligned with the calculation of fines that, for example, the European Commission is having in the application of 101 and 102. So depending where the practice has been developed, you may face a situation of inequality. So I think that a bit of harmonization in the methodology of calculation of fines would be, I think, welcome and would clarify and would provide legal certainty also for companies that would know that an infringement of 101 or 102 is more or less the same everywhere. So I think that that would help also for the internal market consistency. That is something. Another thing that I would recommend is tackling the issue of statutes of limitation, limitation periods, because it's not the same thing everywhere in Europe. A grave infringement of Article 101 in Spain has a longer period of statute of limitations that in the Commission, for example. And this is something that we, before ECM Plus, it was even more problematic because the statute of limitation was not interrupted in Spain when consulting the European Commission or when appealing before court. So if the European Commission was taking longer in assessing whether they wanted the case or not, it had happened in the past that the case was barred from action in Spain when the Commission answered, I'm not interested in the case. So thanks to ECM Plus, at least we have now the same interruption of deadlines, but still we don't have the same statute of limitations. The periods are longer in some member states than in others. So I think that would help as well to have a better view of that. Now, there are other things that may be more troublesome, in particular in this audience, like, for example, the different approaches to the legal professional privilege that we are having in different member states. In some member states, it's wider than in others, and we've encountered difficulties in fighting against, in our investigations, in fighting against theoretically or not protected documents, because legal professional privilege of in-house lawyers, for example, is not clear all over the spectrum. And in my view, not all of them are in compliance with the European Court of Justice case law. But the fact is that in many member states, there are legal professions that protect in-house professional privilege, while in others not. So I think that would be as well something that we as competition authorities would welcome. And then a last thing that, because there has been discussion on whether we should reach convergence in all the typifications of the practice, that is, barring national competition authorities from applying stricter national rules in the equivalent of Article 102, so unilateral behavior. And there, I have to say that, for example, we have in Spain Article 3, which would allow us to intervene when there is an unfair competition practice that not amounting to, for example, abuse of dominant position, is able to restrict competition or have an impact in competition in itself. And I have to say that the possibility of, and same thing, for example, in France, where they have the abuse of, economic dependence or things like that. I have to say that convergence there would, in my view, not increase deterrence for the internal market, would not increase convergence. I don't see a problem with that. And on the contrary, it could be detrimental, in particular for small and medium-sized companies, because even if you're not reaching the level of dominant position, you may be confronted to situations in which this particular article is helping a lot SMEs in our territories. So again, going back to my previous point, point on the booking case, I believe that what is happening is that we may be more in the front line, and therefore, for that, I would advocate not to eliminate this kind of provisions. And I will stop it here.
Thank you very much. Very clear wish list, I think, and I suppose that a number of national competition authorities present in the room may share your views. Moving to Fernando, from the point of view of the Commission, and because we talked, of course, about the increased and improved investigative powers, also concerning this growing digitalization, what would you think are the areas in greater need?
Yeah, well, I don't have a personal shopping list of issues. Well, I'm talking here more in a personal capacity, but I can explain a little bit the issues which are being discussed at the moment. There was a call for evidence back in July for our impact assessment, where already a few topics, a few ideas were tested as to their impact. And you can see already there a sort of possible list of issues that may come up in a proposal. Again, I don't know what the proposal will look like. This is not a decision for me to take. There may be issues which are there, which are not finally reviewed. There may be other issues which are not yet there, which are going to be reviewed. But just to give an idea of the issues which are at the moment being assessed, and I will, there, insofar as the Commission is concerned, there are issues of powers of inquiry, decision-making power, access to file issues in the broad sense, as well as the issue of whether or not we still need a system of complaints, because we don't have a system of complaints in other areas, such as DMA or mergers, but we'd have one for antitrust. I will only say a few words about powers of inquiry and decision-making. About powers of inquiry, you see what is on the table. It's about a bit refining some of the existing powers where we already have. Inspection, for example. At the moment, Regulation number 1 was written at the time where we didn't have servers located everywhere in the world, people working from home. So the idea is to try to modernize the power to carry out inspections, which are not necessarily based on a physical presence of the inspectors in the company. The power we have to have witness statements at the moment is purely voluntary. There are no fines to try to reinforce that power, to be able to actually summon someone, and also, of course, to have the relevant fines in case, for example, this someone lies or provides misleading information. So I said, I think this is more a sort of refining of the existing powers. There is also on the table the idea of having, we can call retention orders, which is not yet the production of evidence to the Commission, but basically the preservation of some type of evidence to avoid the risk of evidence disappearing. It is already provided for in DMA. It's been used there. Back in March 24, we adopted the first decisions of this type. But it's still a new tool. We need to think about it, how to draft it, what is it for. So we're still thinking about all these issues. And of course, in the context of this public consultation, a lot of ideas about the usefulness of this instrument have been already exchanged. We will see how we take it further. The question, for example, on decision-making process, there are, as I said, for example, Article 9 was a very important tool we have. I don't think revolutions are to be expected there, but there is talk about, again, improving some of the existing power we have, interim measures. Shall we eventually change the legal test? Shall we simplify the procedure? At the moment, the procedure involves a written reply to an SO, a hearing, full access to file in the traditional sense. Is it possible to eventually simplify so as to make it more effective? Because the idea, of course, is to make all these instruments more effective. I was saying before that nowadays, even if we have tools that allow us to take very quick decisions, Article 9 and others, if a company really wants to fight, actually, it can delay the procedures a lot. And also there is discussions about also how to improve, actually, the commitment route in the sense eventually of imposing some deadlines that would eventually incentivize companies to come as early as possible. We have decisions which are adopted under Article 9 after an ESO, eventually to incentivize really companies to come very, very quickly with proposals, eventually to close the case under Article 9. There are other things which are not explicitly mentioned in the call for evidence, but which are being discussed. We also expect in case law, for example, request for information. At the moment, there's a lot of discussion about powers of inquiry and privacy. I think Mark knows it well. There are a number of cases we are expecting either criminal references, because they concern powers of national authorities and how this balance is to be struck, but also our own powers. There are also, as I said, in general, issues about Article 7 procedures. Some of them can become very long. Is it possible to simplify things? As I said, the problem being that the mass of information is really enormous, and sometimes just the management of all this evidence has become a bit of a problem. And of course, the big issue is to what extent is there a real need to change in the decision-making powers, the possibility to impose structural remedies. Structural remedies are possible, and the regulation does provide it, but the text appears to suggest this is sort of the ultimate weapon. Is it possible to eventually change a little bit the text to make it a bit more, more effective, these possible powers? It's something, as I said, that we are discussing at the moment. Just two things a bit in reaction to what Kani and Richard were saying. Teletupolska, I was agent there, so I'm well aware of the case, and I think it makes sense that actually competition authorities cannot take inapplicability decision. If they think that paragraph 3 is to be applied, they just close the case. There is no problem whatsoever. One goes back to the 2000s. There was the risk, and this risk is even more present nowadays with the case that we have on Nevis in Idem, that anyone could just deliver a positive decision that would actually prevent the Commission from investigating the case. And if you read Mazak's opinion, the Advocate General, was really a very convincing, I think, plaidoyer for the system as it is. And I think we're all aware that some national authorities would like to cover even many other things in this revision of Regulation Number 1. But I think some of these changes may have to wait. Maybe we will have one day ECM++ or something like that. Because the risk, if you want to propose too many things, of course, is that it will delay the adoption of anything you want to propose. There is a balance to be struck by the final decision makers in the Commission about how far we can go. Because, of course, if you have a more modest proposal, it goes quicker in the Council. If you have a very ambitious proposal, it's very ambitious, but it takes years. I think there is a balance to be struck that will have to be struck next year when the Commission finally makes its proposal.
Thank you very much. Very interesting references. I think, of course, the decision-making powers are extremely important, since there are some concerns being expressed regarding interim measures, but of course, and structural remedies, but you mentioned all of this. And also, thank you for raising this issue of the risk of incoherence if, national competition authorities could actually issue the declarations of inapplicability. Richard, you have the final word. I would like to ask you if you wanted to please talk to us about the impact of Regulation 1/2003 in the empowerment of national courts and any other procedural issue that you think could be improved.
Well, I think I've given my general view of the regulation, which is that it's worked very well and that bringing in the NCAs to the enforcement process has been highly successful and has contributed to the development of the law. In terms of going forward, there are just two things I will be interested to watch, and one is the question of interim measures. And the point here is, of course, until Regulation 1, there was no explicit power for the Commission to grant interim measures. It was created by case law in Camera Care against the Commission, and it was to some extent codified in Regulation 1, but it was written very carefully and set the bar for the Commission very high before it could adopt interim measures. Some of the member states' laws have the bar at a lower level, and there have been more interim measures at national level than at Commission level. Indeed, in 20 years, there's been one interim measures decision. And I know that within the Commission, I mean, Fernando could say much more about it, but I understand that there was, but there was quite a lot of reluctance to go down that road, but it was done. And I just think to myself, mightn't it be helpful if the Commission more often could adopt interim measures? We think of the kind of problems that authorities look at. What was the problem with the digital platforms, those type of markets? One of the problems was the possibility of tipping. And we know that some of those markets have tipped. And then an Article 102 case from beginning to end can take 5, 7, 10 years, might never end, like Intel. Now, if the problem with a market is the possibility of tipping, interim measures might have quite a useful role to play in a case like that. A different point is there's been more of an appetite in in competition authorities in recent years to proceed against excessively high prices. Quite a number of cases now, actually, across the whole network. And I've seen how these cases have played out in the UK. And for the CMA, they have been immensely difficult because there are endless arguments over what is the legal test of an abusively high price. Even more arguments about economically, how do you allocate the costs and what's the rate of return that's reasonable, and so on and so forth. So what I'm saying there is that lawyers and economists between them, they can make an excessive price case run for years and years and years. And presumably, in the meantime, they are charging the excessive price. Well, you can see where I'm going, can't you? Interim measures to keep the price there, I wonder if the legal and economic arguments would go on for quite so long in those circumstances. So just a thought. The other thought is about complainants. And there is a notice on handling complaints. And I won't go back to the case law of the 80s and 90s because to a large extent it's codified in the notice. But I remember the 80s and 90s and the plight of complainants because back in those days there weren't that many competition authorities that were particularly active. There were still member states that didn't even have a competition law. And also, in those days, there wasn't a lot of private litigation. And so actually, to take a word from the DMA, the Commission, in a sense, was the gatekeeper. If I was being harmed by an infringement of competition law, really, I needed the Commission to sort it out for me. And so I would complain to the Commission, and then the Commission would say, no, we're not going to deal with the complaint. And you had endless cases going to the courts about the rights of the complainant. Could the Commission decide not to investigate? If it decided not to investigate, did it have to explain to you? If it did explain to you in a formal letter, could you then appeal against that letter? Was it a decision? And believe me, there was a lot of jurisprudence. And a particularly important case was Automec 2, which was somewhat foundational, actually. So all of that led to the procedure that you've got today as to how the Commission handles these cases. And Judge van der Woude was talking about recent cases in his court where you have Mr. Sventers or you have Lauder Motion complaining about the rejection of a complaint, and the Commission has to spend a lot of time dealing with all of that. Then it goes to the General Court, and the General Court has to deal with a lot of that, with that. And I wonder, frankly, if all of this is a useful use of resources, in particular in a world today where the private litigation landscape is profoundly different. And across the whole of the EU now, we see firms going to court, seeking damages, sometimes seeking interim measures and so forth. So that gatekeeper role that the Commission had back in the 80s and 90s, it's just not as important as it once was because the damages claims are contributing massively to the enforcement of competition law. So what we have today is very, very different from 30, 40 years ago. And it's very interesting. In Portugal, I mean, maybe the fines were annulled for limitation reasons. It doesn't mean to say there mightn't be a damages claim. And in terms of the importance of private litigation, I don't know whether people have picked this up yesterday, but our Competition Appeal Tribunal yesterday awarded a class representative £1.5 billion in damages against Apple for infringements in the way it operates its app store. And that is interesting because our CMA is investigating under our new ex-ante regulation whether there need to be obligations imposed on Apple in relation to the app store. But the cat got there first. It is already decided that Apple is abusing by exclusivity, tying, and excessive pricing. So the world today is very different from how it used to be.
Well, thank you very much. I think this is a perfect reference to close this panel because of the importance, of course, what I think is still called private enforcement of European competition rules. I'm sure the practitioners in the audience will be very encouraged because in Portugal there is a lot of activity in that front, but also maybe national competition authorities because private enforcement contributes to more effective enforcement of European competition law, and this is in the end what matters for a better functioning European single market. Thank you very much to our speakers for their very valuable insights and very good suggestions, I should say. Thank you again to the Portuguese Competition Authority for organizing this discussion on a timely topic. We have with us already the Executive Vice President of the European Commission, Teresa Ribeira, who I'm sure will talk of very interesting things, maybe also a little bit about the future of Regulation 1/2003. Thank you.